The question is, who gets to decide the meaning of marriage? Is it people acting through the democratic process, or is it the federal courts? And our position has been, it's the people.
The court, absolutely, it's their job to make sure that every individual's liberty and equality is protected, regardless of state laws.
Those were the attorneys on both sides of the gay marriage case currently before the Supreme Court. John Bursch arguing on behalf of the states, trying to restrict the definition of marriage to one man and one woman, and Mary Bonuato, who's representing the plaintiffs seeking a constitutional right to gay marriage. Joining us to analyze the oral arguments at the High Court this week is the original lead counsel for the Hobby Lobby religious freedom case, former attorney at the Becket Fund, and an attorney who filed an amicus brief on behalf of several states, Kyle Duncan. Kyle, thanks for being here.
Nice to be here, Ron.
Now, I want to get right into these sound bites of some of these oral arguments and get your reaction as we go along. Okay. Some of the justices voiced concerns about changing the definition of marriage. They questioned whether this was a definition the court could change. Now, this is Chief Justice Roberts and Justice Kennedy. Listen.
Every definition that I looked up prior to about a dozen years ago defined marriage as unity between a man and a woman as husband and wife. Obviously, if you succeed, that core definition will no longer be operable.
This definition has been with us for millennia. And it's very difficult for the court to say, oh, well, we know better.
Now, this point was also echoed by Justice Scalia. And he said, up until 2001 in the Netherlands, no one could point to a country that had actually validated same-sex marriage. Where does this leave us? What does legalizing gay marriage change?
It changes the definition of marriage. It changes the bedrock definition of marriage. It changes what it means. And as the justices were pointing out there, before 2001 in the Netherlands and before 2003 in Massachusetts, no state and no country had ever recognized this new form of marriage. And so I think many of the justices expressed deep skepticism about their own authority to enact such a change, as if there were some sort of super legislature instead of a court of law.
Yeah, there was some hesitancy on the part of the justices. Even the more liberal wing of the court, Justice Breyer, expressed reservations about the courts stepping in and forcing states to accept gay marriage, getting ahead, if you will, of the legitimate political process. Where's that hesitation coming from?
I think that hesitation is coming from the fact that you already have a political process going on in this country in which proponents of same-sex marriage have won some really stunning victories in many states, in something like 11 or 12 states. And the court is sitting there looking at that thinking, well, what gives us the authority to sort of interrupt that political process? What Chief Justice Roberts at one point says, how can we shut down the debate and close minds on this issue by simply decreeing what our own personal view of the institution is?
I want to move on. There was an exchange about the consequences of changing the meaning of marriage and the state's intentions. This is John Bursch arguing on behalf of the states. Listen to Justice Kagan's response.
We want to encourage children to be bonded to their biological mother and father.
Is difficult for some people with your argument is that it's hard to see how permitting same-sex marriage discourages people from being bonded with their biological children.
If you're changing the meaning of marriage from one where it's based on that biological bond to one where it's based on emotional commitment, then adults could think, rightly, that this relationship is more about the adults and not about the kids.
Is this a convincing argument to your ears as an attorney?
I think the more convincing argument is that when you take an age-old definition of marriage, an age-old bedrock social institution, and you just change it, no one can possibly predict with any degree of confidence what are all the ramifications for our society that are going to take place. No one, for instance, could have predicted all of the social pathologies that resulted from no-fault divorce, which at the time many people were saying, oh, well, this will strengthen marriage, this will help children. We now know the opposite. This is a far more radical change than no-fault divorce, and no one can possibly say, I know what's going to happen. No one has a crystal ball and say, here's what will happen, here's who it will harm. And I actually think what Justice Kagan says there is the wrong question. I think it's wrong to make the states say, well, prove to me what might happen in the future that's bad. No one can possibly prove that. The right view, which is the view that we expressed in our amicus brief for the states, was that this is an issue that's traditionally been left up to state citizens who deliberate about what their view of marriage is, what their view of the historic definition of marriage is, and what their view of equality is. That's what Justice Kennedy wrote in the Windsor opinion, after all, 2 years ago. And I think you heard some skepticism from the court based on this idea that you can't possibly know what the court would have wrought if it changes the definition of marriage.
But what about that argument? Because he's clearly making the case here that there's a state's interest in protecting marriage and this definition of marriage because of the children involved, and that the institution's there to serve, if you will, the children and therefore the future of society.
I think that's always been a major part of marriage, of linking children to their biological parents.
I feel a but coming on, but
as far as predicting, what's going to happen if we change one thing, or how are people going to react, that's up to the citizens of the states to decide. It is what has happened. For instance, in 2011, the people of New York decided, well, we think that the definition of marriage has evolved in our communities, and so we're going to open up the definition a little bit broader. It's the right of the people of New York to do that, but it's also the right of the people of Louisiana or Oregon or Washington or Texas or what have you to come to a different view about what the definition and what the meaning and the social meaning of marriage is.
But how then do you get around equal protection? How do you get around that? If my wife and I are married in Louisiana and we travel to California, our marriage is recognized in California. You've got people who are illicitly married in the state of Massachusetts with the consent of those people, who then travel to Louisiana. Well, their marriage is not recognized.
That's right. The states.
Isn't that a strong constitutional point?
Well, that's the second question in the case, and it really goes to what's called the full faith and credit clause of the Constitution, which Justice Scalia brought up at the beginning of the argument, and that is a clause that has not gotten much attention. It's interesting that the plaintiffs are not basing their arguments on the full faith.
They're not citing it at all.
They're not, and they're doing it for good reason, because no court has ever held that one state must automatically recognize the marriage of another state. It typically happens because the states have largely been in the same ballpark when it comes to marriage, and they differ sometimes at the margins. But it's always been recognized that states have the authority to say, no, you've gone too far. It doesn't happen often. But here what you have is a novel revolution in the definition of marriage that has occurred over the process of 5, 7, 8 years. And so it's understandable that states would say, wait a second, the other states are going too far, and our public policies are completely opposed to this.
I want to play this for you. This is Justice Scalia, Antonin Scalia. He raised this point about clergy who refuse to perform gay marriages on religious grounds, based on religious grounds. Would they be allowed to refuse gay marriages if this became legal under the Constitution? Listen.
I'm concerned about the wisdom of this court imposing through the Constitution a requirement of action which is unpalatable to many of our citizens for religious reasons. Were the states to adopt it by law, they could make exceptions to what is required for same-sex marriage. Once it's made a matter of constitutional law, is it conceivable that a minister who is authorized by the state to conduct marriage can decline to marry two men if indeed this court holds that they have a constitutional right to marry?
Your Honor, of course the Constitution will continue to apply, and right to this day, no clergy is forced to marry any couple that they don't want to marry. We have those protections.
But right to this day, we have never held that there is a constitutional right for these two people to marry, and the minister is, to the extent he's conducting a civil marriage, he's an instrument of the state. I don't see how you could possibly allow that minister to say, I will only marry a man and a woman, I will not marry two men.
You've done a lot of litigation in this religious freedom area. What is the implication of allowing this thing to become constitutional, gay marriage to become the law of the land.
This is the elephant in the room, Raymond. What Justice Scalia is getting at is the court essentially, if it recognizes a constitutional right to same-sex marriage, is it at the same time printing a license to persecute and discriminate against Christian schools or any other religious believers who hold to the traditional definition of marriage? So Justice Scalia used the example of a minister who's being forced to officiate at a gay wedding. Now, that one probably, we hope, is covered by the First Amendment. The First Amendment would prevent that from happening. But we see all sorts of disputes now breaking out in states like Indiana and other states with bakers and florists. And it's important to recognize what's at stake in those disputes. What is at stake is not, can they refuse service to gay people, as if they want to put up a sign that says no gay people allowed. No one wants to do that. That's silly. No one's arguing for that. The argument is, can you force people to participate in a gay wedding against their conscience? That's the issue.
But the people on the receiving end of that would say, it doesn't matter how you justify it in your head, the outcome is the same. You're discriminating, you're not serving gay people.
You're not what I think.
You're justifying it as I'm not doing this on religious grounds. I'm not taking part in your marriage, so I won't bake the cake. But to the person asking for the cake, they're saying, you're discriminating against me because I'm gay and I'm in this gay marriage.
So, for example, the cake baker and the florist in these cases already was serving gay people. There's no question about discriminating against gay people.
But when gay people
the line
want to marry,
gets drawn, yes, because they're being asked to participate in the ceremony. And one would have hoped, before all these controversies developed, that all Americans of goodwill could have had a live and let live attitude. You get married, but don't make me come to the wedding. Don't make me participate in the wedding. And now we're seeing that this consensus was very fragile and is breaking down rapidly. And the point is up until now, the court has not recognized a constitutional right to same-sex marriage. If it does so, is it printing a license to persecute churches? And I think, from comments by the Solicitor General of the United States, Christian schools and people need to be afraid of that.
What did he say?
He responded to a question from Justice Alito, who asked him, if we recognize the constitutional right, could the federal government remove the tax exemptions of, for example, a Christian school that continue to adhere to the traditional definition of marriage? And the Solicitor General wouldn't say no. He said he'd have to know more about it, but he said it would be an issue. Now, that should frighten, and frighten is the right word, any Christian church, school, and for that matter, Jewish or Muslim or anybody, any religious group that holds to the traditional definition of marriage that every state had recognized before 2003. Every one of those groups should be afraid that the government will now view them as open season on them because of their now unconstitutional view on marriage.
Justice Roberts made the point, and I think when you look at the polling data, the point is abundant. You're pushing 60% approval of gay marriage in the United States, according to these polls, moving into the 60% range on some of them, but above 50 in a lot of them. The Chief Justice said, look, he was amazed at how quickly this has happened, the speed with which this has moved from opposition to acceptance of gay marriage. What happened to cause that, in your estimation?
I have no idea, but I think...
No idea?
I have no idea, but however, someone said something about statistics. I don't remember what the quote is exactly, but it has to do with lies. Here's a better statistic. If the courts were not forcing the states to recognize same-sex marriage, you might have same-sex marriage in 11 or 12 states in the District of Columbia, but you wouldn't have it in 2/3 of the states. That seems to me a much more reliable indication of where people actually are on this issue. Sure, have more welcoming and understanding attitudes toward gays and lesbians. Sure, that makes sense to me. But the idea that that translates into an unquestioned acceptance of gay marriage, I don't see any evidence for that. What I see is a minority of states that adopted it over a very short period of time, but that 2/3 of the states still don't. And you have the federal courts trying to push this issue and effectively doing it.
Kyle, you have Quinnipiac's poll, hardly a liberal polling company. Republicans are at 33%, 59% are still opposing. Democrats, 74% to 22% opposed. But overall, 58% of Americans are saying, do you support or oppose allowing same-sex couples to get married?
Then what?
It's a pretty straight question. ABC, Wall Street Journal, same thing, 61% approval
what do you need courts for then? If people are supporting it to that extent, why do the courts have to come in and protect minorities
that was the
who have
Roberts
such
point.
Political power?
Let it happen in the states was their point.
That's the point we make in our brief for the states. Why not let the people work this out instead of recognizing a constitutional right and printing a license to persecute Christian and Jewish and Muslim believers who take a different view?
I want to get this quote in. It's very important. Justice Sam Alito suggested that under the Constitution, marriage between two people of the same sex represents a substantial break with what we have today, which could lead to other types of marriages. Listen.
These are four people, two men and two women. It's not the sort of polygamous relationship, polygamous marriages that existed in other societies and still exist in some societies today. And let's say they're all consenting adults, highly educated. What would be the logic of denying them the same right?
How far is this going, do you imagine? If we are to see in the coming days, by June, the Supreme Court decide there is a constitutional right to gay marriage, does this open the door to these other relationships?
I have no idea. I hear news reports about, for instance, California recognizing that a child could have 3 genetic parents. I've heard that in Great Britain as well. Justice Alito's point is about logic. He was simply asking the question of what principle in logic or in law can the plaintiffs identify that would distinguish their situation from 3 or 4 person marriages. And I think if you look at the transcript, you won't see an answer to that question. You'll see the plaintiffs waving their hands vaguely at sort of the states may have interests, but the states are talking about their interests now with respect to same-sex marriage. When the polygamy case comes up and the states talk about their interests, are they going to be laughed out of court the way that their interests have been laughed out of court in these cases?
Put your prognosticator hat on. Where does this go? Given what you heard, given where everybody is, what you heard from Justice Kennedy, it was clearly the swing vote here. What happens?
Justice Kennedy is sending conflicting messages, I think, as everyone is recognizing. And that doesn't mean he's necessarily conflicted on the matter. I don't know what his mind is on the matter. But he's asking hard questions of both sides. So I don't think you can predict on the basis of oral arguments what's going to happen. I think it's safe to say it's going to be a 5-4 decision one way or the other. But I'm not telling you anything that you don't already know.
So you're not saying, you don't, do you believe it's leaning toward allowing the states to do this and not granting a full constitutional right? What's your best guess?
Based on what the courts are courts of precedent, right? They look to what they've decided in the past. Right. 2 years ago in the Windsor case, Justice Kennedy wrote that the federal government cannot have a national definition of marriage because it's always been up to the states to come up with their own definition of marriage, and some states have kept the traditional definition, and other states like New York, for instance, in 2011, adopted same-sex marriage. Now, if this is based on logic and reason and precedent, I don't see how the states could lose. Now, if it's based on something else, then I can't confidently predict what the outcome's going to be. But if it's based on precedent, which is what I thought we lawyers were supposed to look to, then I don't see how Justice Kennedy could recognize the states get to define it 2 years ago and now say, but the court gets to define it now.
Kyle Duncan, we'll see what happens in June. Thank you for being here.